Call the case of the People versus Jason Smith.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Smith, who is in custody. State your name for the record, Mr. Smith.
Jason Charles Smith.
All right. Taking time to have preliminary examination. Are we ready to proceed?
Yes,
All right.
This is right here.
And call your first witness.
would be calling Marie Bradley, and our victim advocate has gone out and going to grab her right now.
All right.
You see, raise your right hand. Swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. But have a seat. State and spell your first and last name for the record.
Thank you. You may inquire.
Thank you very much for being patient with us today, Ms. Bradley. I really appreciate you being here. If at any point you need to take a break, just let me know, okay?
Right out of the gate, this courtroom already has that tense energy where everybody knows the situation is messy before the real testimony even starts. You've got the prosecution carefully easing this witness into the story, and honestly, that tells you a lot. When a prosecutor slows things down, offers breaks, points out tissues, and creates a comfort zone before the key questions even begin, it usually means the witness is emotionally fragile, nervous, or expected to talk about something serious and potentially traumatic. And remember, this is a preliminary examination, not the full trial. The prosecution's mission here is not to prove guilt beyond a reasonable doubt. Their goal is much smaller but still critical. Establish probable cause that a crime likely happened and that Jason Smith likely committed it. Now watch closely, because these early identification questions matter more than people think. The prosecutor is laying foundation brick by brick, confirming the defendant's identity, placing him in the courtroom, and preparing the witness to connect him directly to the alleged assault. That may sound routine, but in criminal court, routine details are everything. One weak link can unravel an entire case later. And already you can feel the tension building toward whatever happened on September 17th. The courtroom is calm right now, but everybody knows the uncomfortable part is coming.
And there's tissues to your right if you need them. Do you know a Jason Smith? How do you know him? Okay. And is he in the courtroom now? Can you briefly describe something he's wearing and where he's sitting? Your Honor, please let the record reflect that the witness has made an in-court identification of the defendant.
Record shows so reflect without objection.
I'm going to direct your attention to September 17th, 2023. Okay? Were you at 930 North Congress Street in Ypsilanti, Michigan, Washtenaw County at that time? On that date, did the defendant do something that made somebody call the police?
Yes, struck me in the face.
Okay. Can you break that down for me a little bit? How did it start?
It started because he wanted me to go in the room and leave him alone.
Where were you? I apologize for interrupting. You said he wanted you to go in the room. Where were you when this started? Outside? Okay. And what happened when you were on the porch outside?
Well, he was telling me to go outside and leave him alone. We were both intoxicated. I didn't want to leave him alone. And I don't even remember him yelling at me. He close to fist and touched me in the nose area
On the front porch?
on the front porch.
Okay. And did he say anything else other than to leave him alone prior to punching you?
This is where the testimony suddenly shifts from vague relationship conflict into a direct allegation of violence. And notice how carefully the prosecutor is navigating it. Up until now, the witness has been describing arguments, yelling, emotional chaos, and confusion, but now the questioning is laser-focused on one key issue, the alleged punch. That's because, legally, this entire hearing may rise or fall on whether the court believes there's enough evidence that physical assault actually occurred. And pay attention to the witness's wording here. She doesn't sound polished. She doesn't sound rehearsed. In fact, She sounds uncertain, emotional, and fragmented at times. Ironically, prosecutors sometimes believe that makes a witness appear more authentic because real-life traumatic incidents are often messy and inconsistent. But defense attorneys love moments like this because every hesitation becomes an opening later. Also notice something important about the relationship dynamic emerging here. The witness casually says they kept rolling afterward, like this kind of behavior was almost normalized. That's a massive emotional red flag in domestic violence cases. Courts hear this pattern all the time. Violence allegedly happens, emotions cool down, the couple continues talking, and the situation becomes blurred instead of immediately exploding into police action.
Okay. Do you know how many times he hit you? Once? Okay. And can you tell me what happened after he hit you?
We just sat there, was talking,
Afterward?
yeah. I mean, it was kind of a normal thing. So I just wiped it off and kept rolling.
Okay. And did you call the police or did someone else?
What do you had driven by? Had some witnessed it and
Objection, Your Honor. We're getting into either speculation, hearsay.
I'll sustain the objection. Go ahead. Next
But you
question.
did not call the police?
no, I did not call the police.
Okay. Did anything else physical happen between you and the defendant on September 17th, 2023?
No.
Okay, 1 second, Your Honor, please.
Yes.
No additional questions at this time.
All right, cross-examination.
Thank you, Your Honor. You indicated that you and he had been drinking.
Yeah.
How much did you have to drink?
I couldn't tell you. But
When you say a lot, could you be more specific?
I honestly don't remember.
More than 5 drinks?
Absolutely.
More than 10 drinks?
Probably up to 8.
What were you drinking?
It would have been, whiskey and coke,
Whiskey?
or it was my car lemonade.
Well, which one were you actually drinking that day?
Oh,
You don't recall what you were drinking. Were you using any other substances?
No.
Anything else? Were you using crack? So how much marijuana did you use?
probably 2 pre-rolls. Grams.
So you had 2 pre-rolls and at least 8 drinks.
Yep.
And those drinks might have been whiskeys. They might have been Mike's Hard Lemonades.
And here comes the defense strategy in full force. This cross-examination is not subtle at all. The attorney is systematically attacking the witness's reliability by building a picture of extreme intoxication. Multiple drinks, uncertainty about what alcohol was consumed, marijuana use, confusion about timelines. Every single answer is being used to plant one giant question mark over the prosecution's case. This is classic defense work in assault hearings. The goal isn't necessarily to prove the defendant innocent at this stage. The goal is to make the judge question whether the witness's memory is dependable enough to support probable cause. And honestly, the attorney is hammering hard on the contradictions. First, the witness remembers yelling. Then maybe not. Then she's unsure again. That kind of inconsistency becomes courtroom fuel immediately. But there's another layer here that matters. Even though intoxication can absolutely affect memory, courts also understand that intoxicated people can still accurately remember moments of violence, especially sudden physical acts like being punched. That's why the defense keeps trying to widen the memory gaps beyond just the alleged strike itself.
Right. Yeah.
Fair to say that you were intoxicated,
Absolutely.
highly intoxicated. So much so, in fact, that the police took you to the hospital, correct? Against your will.
Yep, I made sure that he wasn't going to jail that day.
So the police took you to the hospital because you were so intoxicated.
Right.
When you get intoxicated, does it affect your recollection of things?
Okay.
Did it affect your recollection in this case?
Yeah, up until about the punch.
So you don't remember what happened before the punch or what happened after?
Being upset that I kept following him, wanting to talk to him. Oh,
When you say he's upset, what was he doing?
yelling at me.
Okay, you testified earlier that you don't remember him yelling at you.
I don't. Well, I mean, that's just our usual thing.
Okay. You testified earlier that you don't remember him yelling at you.
Okay.
And now you're testifying that he did yell at you.
Well, okay, I can't say whether he yelled or not, but he was telling me to go in the bedroom and look.
Okay. So now he didn't yell.
I don't.
You don't remember.
No.
Okay. So when you testified just now that he was yelling at you, was that untrue? Did you remember it then and forgot?
I don't know.
Did he, in the course of this incident, lock you out of the house?
I don't remember on that day when they left that. No, I don't believe so.
No? Do you recall if you tried to break into the house by popping open the front screen door and entering the residence?
No,
You don't recall, or that didn't happen?
no, they haven't.
Okay,
Not that
so,
I recall. No, I have to say that, not that I recall.
okay. Do you recall if you tried to pop the screen off the back door to enter the house?
Not at that time, no.
Do you recall going into the house on that date?
Oh, yeah, in and out, beautiful day out.
Okay.
This section is incredibly important because the defense is no longer just questioning memory, they're subtly suggesting alternate behavior from the witness that could change how the entire incident is interpreted. Listen carefully to the pattern of these questions. The attorney is asking about locked doors, attempts to get into the house, screen doors being popped open, repeated movement in and out of the residence. That's not random, that's strategic. What the defense appears to be doing here is constructing a possible scenario where the defendant may have been reacting to escalating behavior instead of initiating unprovoked violence. Now, importantly, the witness is mostly saying she does not recall those things happening. But even "I don't recall" can become useful to the defense because uncertainty itself creates room for argument later. And notice how intoxication keeps hovering over every answer like a cloud. The more memory gaps appear, the harder it becomes for either side to present a perfectly clean narrative. That's why preliminary examinations can become so fascinating they're not polished jury speeches. They're messy collisions between imperfect memory, legal standards, and strategic questioning.
Yeah,
When you're intoxicated as you were on that day, do you ever fall down?
no,
No?
no,
No, I said ever.
no,
So when you get really drunk, you don't ever fall down.
no.
Not that you recall. May I have just a moment, Judge?
Yep.
No further questions, Judge.
Any redirect? You may step down. Thank you, ma'am. Any additional witnesses for the people?
No, Your Honor.
Any witnesses for the defense?
No, Your
Motion,
Your Honor, the people move to bind over on count one.
response.
Honor, defense would object. There's no evidence to support that there was anything, any injuries, there's no pictures, there's no testimony from any other witnesses to support that this even occurred. The complaining witness freely admitted she was extremely drunk. She was abusing both alcohol and marijuana at the time, to the point, as she testified to, the officers on scene forcibly took her to the hospital against her will. She is not a reliable witness at that level of intoxication. The court is well aware that it is obligated to consider the credibility of the witness, and she is not credible. I would ask the court to dismiss the charge.
Court does believe that it's an issue. It's a question of fact as to what she remembered. She clearly testified that the defendant punched her in the face, that she was bleeding.
And there it is, the moment the judge cuts through all the chaos and gets to the legal heart of the hearing. The defense spent a long time attacking credibility, intoxication, memory gaps, contradictions, and reliability. But Judge Simpson is separating two different concepts here: imperfect memory versus complete lack of probable cause. That distinction matters enormously. The court is basically saying this: yes, the witness had credibility issues. Yes, intoxication complicates things. Yes, Parts of her recollection were inconsistent. But despite all that, she still consistently testified that the defendant punched her in the face and caused bleeding. For purposes of a preliminary examination, that can be enough. And this is something viewers often misunderstand about criminal court. Defense attorneys do not need to completely destroy the prosecution's case at prelims to score points. Sometimes their real goal is preserving arguments for trial, exposing weaknesses early, and forcing the judge to acknowledge factual disputes. Meanwhile, prosecutors only need enough evidence to clear the probable cause threshold, not prove guilt beyond all doubt.
As to issues regarding her recollection of other parts of that event, again, those become, I think, issues of fact, weighing certainly on her credibility, but not to the extent that this court doesn't believe the people have met the burden of probable cause. So for those reasons, the court would bind the defendant over as charged.
No, now I'll just see to the information, waive its formal reading, my client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
1:30 before Judge Slay, Monday.
April 22nd, 2024, 1:30, Slay Monday. Thank you.
Thank you, Your Honor.
Yeah.
Court does call the cases of the People's State of Michigan versus Tamar Young, case 23 FB 1433 and 23 F2 0334.
For the
Counsel,
record, the Michigan Senior Assistant Prosecuting Attorney on behalf of the people for both cases.
Good afternoon, Your Honor. Susan Longsworth on behalf of Mr. Young for the 23FB case.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Tamar Young on 23 F2 0334.
and what are we
Going to be waivers on both cases.
on
Your Honor.
both cases?
And with regard to file number 23 FB.
See you next week.
That's the case that Ms. Longford representing.
Yes.
I'm just putting on notice for the court's benefit, although counsel is already aware of it, that we're going to be filing amended information to reflect certain changes in circumstances from when the case was originally filed.
Hold on one moment.
This second case escalates the seriousness of the courtroom dramatically. We've gone from a messy assault hearing into a situation involving amended informations, multiple counts, homicide references, and open murder charges. And when prosecutors start restructuring charges in real time during court proceedings, everybody in the room pays attention because that usually signals evolving evidence, changing strategy, or developments tied to victims and forensic findings. Now listen carefully to what's happening procedurally. Count 2 is being dismissed, but not because the case is weakening overall. In fact, the prosecution is simultaneously adding a count of open murder tied to another named victim. That's huge. Open murder charges are incredibly serious because they leave room for varying levels of homicide liability depending on how the facts develop later. And notice Judge Simpson slowing everybody down repeatedly to clarify exactly which counts correspond to which victims. That's not courtroom filler, that's essential record making. In large felony cases with multiple counts, if the record becomes sloppy, appellate issues can explode later.
Let them finish the conversation because I'm having,
Oh, is there feedback, Your Honor?
no, I'm hearing you while Mr. Gannett is
Sorry.
talking.
I apologize, Your Honor. Thank you, Your Honor.
Go ahead, Mr.
Ms. Longsworth and I had discussed the case over the weekend, yesterday. Count 2 is being dismissed because that was originally charged with and unfortunately, the victim on that case was a murder victim ultimately. So count 2 will be dismissed on the information, and we're adding a count 13 of open murder with Tyrese Burks being the named victim on that count.
All right.
And then when you're ready, I'll keep going through the changes that are happening.
Okay, hang on. So you're going to be adding a count 13 of open murder. Okay, go ahead, sir.
Count 2 dismissed, added count 13. Moving down to count 6, that will be, the language will be amended to reflect that it was a death to Tyrese Burks for the discharge in or out of building causing serious impairment. That would mirror count 7 with the other homicide victim being Travis Williams, if the court follows.
So count 6, I got you. Okay, so count 6, the theory or the basis under that will change. Is that,
Sorry, that would coincide with count 5 of Dallas Williams.
yeah, okay, count 5. That, okay, thank you. All right, that makes sense.
And then when you're ready, I'll finish this off.
Yeah, no, go ahead.
We would also add counts 14, 15, 16, and 17. All 4 of those counts are going to be the same felony firearm. They're going to correspond with a felony of discharge in or at a building causing serious impairment. And essentially they correspond with the charge counts 5, 6, 7, and 8.
Got it. So 14, 15, 16, 17.
Yes, sir.
All right. So effectively, is that everything?
What you're watching right now is one of the most important moments defendants face in felony court, even though it sounds almost conversational on the surface. The defense attorney is making absolutely sure the defendant understands what rights are being waived before giving up the preliminary examination. And that matters because once a defendant knowingly waives prelim, the prosecution avoids having to present witnesses and evidence at this stage. Now, why would somebody waive a prelim in a case this serious? There can be multiple strategic reasons. Sometimes the defense already knows the prosecution can establish probable cause easily, so fighting prelim becomes pointless. Sometimes attorneys want to avoid locking witnesses into testimony early. Sometimes they're already thinking ahead toward trial negotiations, suppression issues, or broader defense strategy. Notice how carefully the attorney phrases everything. Discussions about evidence, possible defenses, mitigating factors, pros and cons. That's all designed to create a clean record showing the waiver was informed and voluntary. Judges take that extremely seriously because appellate courts later examine whether constitutional rights were knowingly waived.
It is, Your Honor.
So effectively, if the defendant were to waive, he'd be waiving over on count 1, count 2 through 17.
2 is dismissed.
I mean, 3 through 17.
Yes,
Thank you.
sir. That's correct.
Schlongsworth, is that a correct statement as you understand it?
That is a correct statement as I understand it, Your Honor. If I may inquire of Mr. Young.
Yes.
Mr. Young, you heard some of the changes that Mr. Ganatra put on the record pertaining to the information that they'll be filing. Is that correct?
Yeah.
Okay. And do you believe that you and I have had a sufficient time to talk about the case, talk about the benefits of holding a preliminary examination and the benefits of waiving a preliminary examination?
Yeah.
And in converse, the cons of both of those as well, right?
Yeah.
Okay. And do you understand that you are giving up your right to hold a preliminary examination, and you're agreeing that the government would be able to show probable cause of these felonies if we were to hold a preliminary examination?
Yeah.
And you and I have talked about other evidence and possible defenses and other mitigating factors that were present. And we've agreed that those are issues that we would raise at trial if necessary. Do you agree with that?
Yeah.
Okay. So understanding all that, is it your agreement that you are going to waive your right to preliminary examination in this matter?
Yes.
Thank you. No additional questions, Your Honor.
And young man, that is what you want to do?
Yeah.
Pardon?
Yes.
People also waive their right to preliminary examination, both men. All right. And sir, you also understand, we talked mainly about case 1433. You also understand in the other case, you're waiving your right to a preliminary examination.
Yes.
All right. Preliminary examination having been waived, and let me start with case ending in 334. Defendant is bound over to circuit court on that single count.
This is the procedural turning point. Once the preliminary examination is waived, Judge Simpson can bind the defendant over to circuit court without hearing witness testimony at this stage. That does not mean guilt has been decided. It means the defendant is formally moving forward into the higher court process on the listed felony counts. And notice how careful the court is being with each case number. That matters because this defendant is dealing with more than one file, and the charges have just been amended. In a case this serious, confusion over counts can create huge problems later, so Judge Simpson is making the record clean. One case gets bound over on its single count, and the larger case proceeds on count 1 plus counts 3 through 17. The defense then waives formal reading, the defendant stands mute, and the court enters not guilty pleas. That is standard procedure, but the stakes are anything but standard.
In case ending in 1433, defendant will be bound over on count 1 and then 3 through 17, as will be reflected in the amended complaint.
For my case, Your Honor, please waive reading. I can acknowledge receipt of the information. Mr. Young stands mute.
And this one.
Your Honor, we waive formal reading, stand mute, and we acknowledge that we have been informed of and will receive a copy of that amended information when it is prepared.
Defendant having waived formal reading in all of the cases to all of the counts, waived formal reading and standing mute to those charges, court will enter a not guilty plea. Pre-trial in these matters will be set
April 1st at 1:30 before Judge Slay Monday.
April 1st, 2024, 1:30 before Slay Monday.
Thank you, Your Honor.
Thank you. Bond will continue as set and or denied in each case.
When I did sign the information for 334 and provided to the court.
Yes, we do have that.
Andrew Meyer on behalf of Major McIntyre. Mr. McIntyre, if you haven't done so already, please state your name for the record.
Mazio McIntyre.
Thank you.
All right.
Your Honor, I do want to make one correction. I do note that last time we were in court, there was representations made that multiple calls were made to the victim after arraignment. However, I do believe only one of the calls was made after arraignment. That is completely my fault. I do want to note, however, I do have a full spreadsheet of all of the calls that the defendant has made to the victim since he has come into custody, not just since the 26th, but also after he was remanded by Your Honor, including 4 calls on March 7th, 1 call on March 8th, 3 calls on March 10th, and 2 calls on March 11th. I do also have an email from Lieutenant Arnett indicating that there were multiple inmates disciplined this weekend for letting the defendant use their PINs in order to contact the victim.
Now the courtroom shifts again, and this time the issue is not just the underlying charge, it is whether the defendant can follow court orders while the case is pending. That is a huge deal in bond hearings. Bond is not just about punishment or sympathy. It is about risk to the public, risk to the alleged victim, risk of non-compliance, and risk that the defendant may ignore conditions if released. The prosecutor is laying out a pattern of alleged calls from custody, including calls after the defendant was remanded. That is serious because courts take no-contact orders extremely seriously, especially when the alleged victim is involved. And what makes this even more damaging is the suggestion that other inmates' PINs may have been used. If true, that moves the conduct from "I made a bad decision" into "I found a workaround to bypass the court." That is exactly the kind of behavior judges do not like. It tells the court that a written order may not be enough, and once a judge reaches that conclusion, release becomes much harder to justify.
I also have a couple transcriptions from the additional calls made between the 7th and the 11th of this month. I do want to apologize for that error with the dates. However, I do want to emphasize that our initial request for bond modification was not solely the result of the jail calls. We did feel that the initial bond being set was inappropriate because of the escalating pattern in this case, with the destruction of the same victim's property on January 7th, escalating to malabuse on January 9th, and then the actual act of physical violence that occurred at the end of February. So we were planning on making a bond argument even without the jail calls being in play.
So just so that I'm clear, and I understand what you're saying in terms of the calls, because sometimes I have to make sure that I have the arraignment as opposed to custody date when when trying to assess these. But then after he was remanded this time by the court,
That is correct.
there are more calls.
That is correct. And I have a spreadsheet and transcriptions if you would like them.
Mr. Meyer.
Your Honor, thank you, and thank you to Ms. Barroso for correcting that. I mean, this was something we had discussed yesterday. I was reviewing the calls and noticed that some of them did occur before the arraignment.
Okay.
But in terms of where we are now, Ms. Barroso did make me aware of these additional allegations of calls. I don't have those yet.
This is a smart defensive move, but it is also a difficult position to argue from. The defense is basically saying, hold on, we do not yet have all the new call evidence, so we cannot fully respond to the contents of those calls. That is fair. A defense attorney should not concede facts they have not reviewed. But here's the problem. The defense is also acknowledging that calls happened when calls were not supposed to happen. That creates a narrow but dangerous admission. Even if the content is unknown, the conduct itself may still violate the court's order. In bond hearings, judges do not always need the full trial-level proof of every allegation. They can look at conduct, compliance, and risk. And if the court had already revoked phone privileges or ordered no contact, then simply making calls can become enough to trigger serious consequences. This is where technical legal arguments collide with common-sense courtroom judgment. The defense wants to limit the damage to "we admit calls existed," but Judge Simpson is clearly looking at the bigger pattern. Orders were given, restrictions were imposed, and somehow communication still allegedly continued.
I only have the ones that would have occurred before the arraignment. So that's the.
So what, you don't have the calls
I don't have the.
basically from this week,
Correct. I don't have those.
this past week.
Right. So I'm not in a position where I can assess what was or was not said on those calls, to whom those calls may or may not have been made to. So I'm in a little bit of a disadvantaged position in that regard. But here's what I'll say.
But those ones are new.
Correct.
Here's what I'll say. Mr. McIntyre and I discussed this. Regardless of what's on those calls, Your Honor did order him not to make any call. I think I reviewed the ROA and it said no phone privileges were revoked. So putting aside what may or may not be on those phone calls, there's a violation. He'll admit to that part of it, that he made a call when he wasn't supposed to make a call, and we'll just leave it at that.
Made a call?
Made calls, excuse me.
And that becomes part of my problem, part of my dilemma. Because at that, I mean, if it isn't clear from the magistrate and you make the calls, then once you get here, I kind of make it clear and I revoke your phone privileges and I kind of make it clear you're not to have contact. And even though I say it, write it, do that, you still just do it. And so in terms of release of this defendant, I don't know that I can trust this defendant to follow any of the court's orders regarding it. I mean, that's the dilemma that we're in.
I don't mean to pile on, but I do want to also raise one additional concern that came out of one of the jail calls, because it did appear to me from one of the calls made prior to arraignment that the defendant indicated that if he thought he was going to be in custody, he would leave court.
And just when the phone call issue was already bad enough, the prosecutor adds another concern: possible statements suggesting the defendant might leave court if custody was on the table. That is exactly the type of allegation that makes a judge's risk analysis shift fast. In bond decisions, courts look at more than the charge itself. They look at whether the defendant is likely to appear, whether they will obey conditions, and whether anyone may be endangered if they are released. So if the prosecution is arguing both continued contact with the alleged victim and possible flight risk, that creates a powerful combination. The defense tries to point to community ties, housing, employment, local connections. Those facts usually help a defendant argue for release. But community ties can only do so much when the judge is already concerned about direct disobedience of court orders. This is the courtroom equivalent of digging out of a hole while someone is still pouring dirt in. Every new allegation makes the defense's path harder. Question for you guys. If a defendant violates phone restrictions from jail, should a judge trust them with release conditions outside jail?
He would what?
He would leave court. And so that to me poses an additional concern of him not wanting to appear if he were to be, if custody were to be on the table.
I mean, in terms of ties to the community, I think I brought this up last time, and he does have a place that he was staying in Ypsilanti prior to him being remanded by the court last week. And he did have a job. I don't know if he'll be able to return to it. I was just in candor to the court, just trying to admit to what I think we can admit to this point, which is that there were phone calls. I just don't know what the content of those calls are.
Right, and Mr. Myers, I often have to indicate to people, for the purposes sometimes of these bond hearings, certainly I'm concerned about what the content may be, but a lot of times that content is really potentially being used for what might be additional charges or other motions if the victim doesn't appear or the like. The bottom line to it, though, is you said no contact.
Right. And that I can't assess whether there was contact with an alleged victim or not at this point. I don't know that after arraignment. I don't have anything in front of me. I do have phone calls that.
Do you, so,
To see it.
Sure. But I didn't have it until.
yeah, right.
Is this your file?
No, I have 3. The court wants one too.
Just while you're also going through that, what is even more problematic is I take away the phone privileges in hopes that when we come back here, there can be at least an understanding, but then apparently he's using somebody else's PIN to potentially try to access.
This is the moment Judge Simpson's concern becomes crystal clear. The judge is not only focused on whether calls happened, he is focused on what the alleged workaround says about the defendant's attitude toward court authority. That distinction is huge. When a judge takes away phone privileges, the expectation is simple: no calls. But if the defendant allegedly uses other inmates' PINs to keep making contact, then the court may see that as a deliberate attempt to sidestep an order. That is far more damaging than a single accidental violation. It suggests planning, persistence, and refusal to comply. And in bond hearings, that kind of conduct can be fatal to release. Because if a defendant cannot follow a no-contact order while physically inside custody, the obvious question becomes, why would the court believe they will follow stricter conditions outside custody?
These ones. Yes, it is.
It's 26.
It's a problem.
It's only them ones right there.
Right. It's after. Do you understand?
And Your Honor, I do want to note that some of the calls were made to a different phone number, but that phone number was referenced in a call from 3-7 to the victim's phone number as a number that would be the point of contact for the defendant to the victim. So that is how we have that information. And that is the number that the defendant was using. Inmate William McDonald, Kamani Hamilton, Rontrell Davis, and Dominic Kelly Payne's PINs in order to contact. Excuse me, not Rontrell Davis or Dominic Kelly Payne. It was just William McDonald and Kamani Hamilton. He used Rontrell Davis and Dominic Kelly Payne's number or PINs to contact the original phone number, just so we're clear.
Your Honor, as I said, happy to admit to the calls they make. That's all I can admit to at this point, or have him admit to.
No, I got you.
Now Judge Simpson is about to put the entire issue into plain language. And this is where the ruling becomes almost inevitable. The defense is trying to keep the admission narrow. Yes, there may have been calls, but they cannot admit to the full details or contents without reviewing everything. That is reasonable lawyering. But the court does not need every detail to understand the core problem. The judge already sees a sequence: a no-contact order, revoked phone privileges, alleged continued calls, and possible use of other inmates' access to reach the victim. That sequence creates a pattern, and courts care deeply about patterns when deciding bond. This is not just about punishment. It is about whether the court can rely on its own orders being followed. If a defendant treats court restrictions like obstacles to work around, the judge may decide there is no safe release plan available. And that is exactly the pressure point here. The defense can argue uncertainty about the call content, but the judge is focused on compliance itself. Once compliance becomes the issue, the content of the calls almost becomes secondary.
Well, and just to put it bluntly, I mean, I told the defendant no contact. Well, the court has told the defendant no contact. We restricted his phone privileges upon his remand back on the 7th of March. Between the 7th and the 11th, really, but certainly within this week's period in time, he's then entered into a scheme to sort of thwart the court's order, both the original order as well as the new order that he not, that his phone privileges were revoked. So for those reasons, the defendant won't be released. The revocation of bond will continue. The defendant will stay in custody. You can bring it up with Judge Perry on the his set on the 19th, so we can go from there. Thank you. He set this Tuesday for
Yes, the 19th.
for preliminary.
Final ruling, and Judge Simpson makes it clear. The defendant is not being released. The bond revocation continues, and he will remain in custody unless the issue is raised later before Judge Perry. That is the courtroom consequence of what the judge sees as a repeated failure to follow orders. So here's the full picture. In the first case, Judge Simpson found probable cause despite credibility issues and bound Jason Smith over on the assault charge. The defense attacked intoxication, memory gaps, and reliability, but the judge ruled those were factual credibility issues for later not enough to dismiss at the preliminary stage. In the second major case, amended serious charges were placed on the record, preliminary exams were waived, and the defendant was bound over to circuit court. Then, in the bond matter, the court focused on alleged jail calls, no contact violations, and attempts to bypass revoked phone privileges. The key takeaway is simple. Courtroom decisions are not always about perfect evidence. Sometimes they are about thresholds, procedure, credibility, and whether a judge can trust a defendant to obey orders. Judge Simpson's ruling shows that when court orders are ignored, bond can disappear fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.